Hello, everybody. Welcome to our employment law update for 2024. Thank you for joining Lucy and I on this webinar. It's live and we'll be taking questions, having some period for questions at the end. So please put those in the chat and we'll try and answer them. So it's been quite a year. We have a new government. They had a commitment to make changes within 100 days. Today is 74 days in, and actually very few changes have happened, but lots of promises and a commitment in the manifesto of significant employment law changes. So this is to give you an update on the law that has actually changed and what has been promised, and hopefully some time frame on this. It was only last month that the Deputy Prime Minister and the Business Secretary got together with unions and some employers. So we think that in the 100 days, what will definitely happen is the Employment Rights Bill will be in force. But that doesn't change anything in itself. It's the mechanisms in which the law can be changed. And there will be a significant period, we hope, of consultation because there is a lack of detail. So we are going to talk about the changes that are definitely in place, coming with their deadlines, which are very shortly, and then this framework of what Labour has promised will happen and that changing environment.
So to start us off, April this year we saw a flood of family-friendly changes take effect. A lot of these we've covered actually last year when they were first being announced, but just to summarise what has changed to make sure that policies are up to date and reflect these changes. Firstly, there were changes to the right to request flexible working. This is now a day one right. Previously, employees used to have 26 weeks continuous service. Now they can make this request from day one. They can also request 2 flexible working requests in any 12-month period rather than 1 as it was before. And employers are required to respond to this within 2 months rather than 3 months. Finally, employers must consult with the employee before refusing any request. That's not a particularly problematic change for most employers. Most employers do consult with their employees, but now that you must do so before refusing any request. We also saw some changes come towards paternity leave. So previously, employees could take 2 weeks leave, but it had to be in one block. Now they can still only take 2 weeks, but they can take that in 2 one-week blocks or in the 2-week block as before. It used to also be that they had only 56 days from the date of birth of the child or the date of placement of the child to take this leave. They now have 52 weeks to take this leave, which is quite a substantial change. In addition to this, we saw some amended regulation regarding maternity redundancy protection. This was an extension of the protected period from when the employee informs their employer that they're pregnant to 18 months after the estimated week of childbirth. So for some employees, this could be up to 2 years protection. And finally, the last big change that the government brought in was carers leave. Now this is a right to 1 week of unpaid leave each year to care for or arrange care for a dependent with a long-term care need. That could be a disabled family member, for example, or it could be for age-related care. At the moment, as I said, this is unpaid. Monica will talk a bit later about Labour's proposals to extend this right.
So what we do have coming into force next month on the 26th of October is this requirement to have a duty to take reasonable steps to prevent sexual harassment in the workplace. I am going to do a little proviso. A lot of the law that is coming into effect, I think, is sometimes quite limiting. So if you're considering protection from sexual harassment, I don't particularly agree that it's just sexual harassment, particularly as this is a duty to prevent sexual harassment by third parties like customers and clients. And my view is that that should be broadened to include any form of harassment on the grounds of race or gender or anything like that, because when particularly retail workers, when they are subjected to abuse, it's not just sexual harassment. So now, if a customer abuses your employee, you may be liable unless you take reasonable steps. And this includes having obviously clear policies, but how you're implementing those policies. So staff know the standards, and real preventative actions like notices going out or being around, how do you contact your customers, and what action will be taken and by whom. So if that duty is not undertaken, so if you haven't done simple things like putting notices up or communication to your customers, then it's very likely that you will get an uplift of the compensation by 25%. It is difficult because you're literally telling people what not to do, and you would hope that you didn't need to do that, but that's the requirement, and some of you will have to look at that if you've not done so already. So let's talk about what Labour is proposing to come into force within a time period, and we'll talk about when we think those might come into effect. So what the manifesto was really talking about was addressing this imbalance of power between workers and organisations. And here you're seeing the accumulation of the cost of living crisis, wage stagnation, yet big profit in companies, and that not translating down to employees, and certain abuses within the labour market. So, and all of these things have been on the agenda for some time, so it's not particularly new concepts, but we have this concept of banning exploitative zero-hour contracts, and I think the key word is exploitative. There are many zero-hour contracts that work very well, particularly for second jobs or for student work, or for people with family commitments doing odd shifts where they genuinely have the power to turn that work down. It's mutually beneficial. So it's the exploitative nature, where there are significant number of individuals that aren't given guaranteed hours, and they can't then get mortgages or have any of that security. So what the proposal is to ensure that there is a guaranteed number of hours that will be offered based on a 12-week reference period. And if there's any there should be reasonable notice if you're going to change shifts or any working time, and then there's compensation if you do that at very short notice. So, and many organisations would be able to fulfil this seasonal requirement for work. Then we have the controversial fire and rehire. And the issue with that is some of the publicity from the P&O Ferries case. And interestingly enough, this week Tesco has lost a case where it sought to amend its terms and conditions. There was a move from one warehouse to another, and they gave the employees a premium payment. And that wasn't a one-off premium payment, that was considered to go on, and then they tried to withdraw that, saying, well, the change has happened, and the court has held that that was an abuse and that's not lawful. Where fire and rehire has been successful is when there is a need, because of the industry changing or the sector or the climate, for there to be an amendment to the contract, but not necessarily an amendment that is a worsening of the contract. It's a change. And whilst it may not be liked, this idea, well, we're offering you broadly the same terms, maybe some compensation. But if you don't accept it, we'll have to end that contract after consultation with you and offer you this new one. And we're hoping that the framework still allows for that to happen. Clearly, what happens in those scenarios is that there is real pressure on the employee to sign up. And that is what I think the law is trying to balance out. Much has been talked about the basic day one rights, and we'll talk about some of them more in detail. But one of them was this idea of unfair dismissal being a day one right. Some of these proposals, we would have been expecting some details by now. And the fact that we don't have is telling probably what a significant amount of work the Labour government has. I don't think any of us are denying they've got a significant workload, but also the actual lack of agreement and clarity between the government, between the unions, which are broad churches, there'll be different views there, in coming up with proposals, and employers have yet to see what that means before they consult. But the idea is that you would have an employee that would be able to bring unfair dismissal claims from day one. The current thinking is that there will be a probationary period. We don't know how long that probationary period will be, 3, 6 months, we don't know, but there'll be a fixed period where you would be able to dismiss, but you would have to follow a process. It can't be the same as the ACAS process, it's have to be something more abbreviated, because that's the ACAS is the unfair dismissal process, but it has to have a reason or cause. So if you look at that, and we know it's coming, and we've had throughout employment, for the time that I've been practicing employment, we've had changes to the unfair dismissal length of service to bring a claim throughout. What you really need to be looking at now before this comes in is hiring right. You know, if you hire right, train diligently, leverage off your people's strengths, trust them, you might have an unstoppable team. The difficulty is it's quite hard to hire right. I think you are better off maybe on a dating app on your personal life than getting the right person. Nobody gets their hiring completely right, but employers should be really looking at the recruitment process, the onboarding process, that training, so that it's very apparent that in that probationary period that this person is just not going to work out, the date's got to come to an end. And most people, if they have an explanation, will understand. Of course, you know, people have day one rights already for whistleblowing and discrimination, but it's that kind of tightening up of your processes that employers should be looking at now, because that's at least one thing that A, makes business sense anyway, and secondly, it'll take lots to do off your to-do list, which will be large by the end of this 12-24 month period. There'll be changes, day one rights to parental leave, and this is the leave where you have 18 weeks leave until the child is 18 years, and you can take that from day one. Both this parental leave and the flexible working request, I think there needs to be a resetting of the employment relationship. So if you are saying in your ads that you're a flexible employee, invite people to tell you about their circumstances, because we find that most employers are annoyed when they think they're getting employee A, but employee A is actually employee C. So it's this idea that if you're open and honest, then some work can be done about doing job shares or accommodating that. One of the things that I personally find very interesting is we thought sick pay, the amendments to sick pay would be so easy to implement. The law's already there, it's just a bit of quick uptake. There's not really that difficult. And Lucy will talk about those changes, but the changes you're talking about are the waiting times and the lower pay thresholds, earning thresholds. that would have been very quick to remove. And I think it hasn't been removed because this problem about the costs, and I think Labour are acutely aware of the cost to employees, cost to employers, but also to the public purse in making these amendments. In all of the variations of Labour's plan to make work pay, and I have all of them, there was a strong threshold, a strong indication in the earlier ones that they thought SSP was too low, full stop. But again, that's gone very quiet on the amount of sick pay that's to be offered under the statutory sick pay system.
So just to continue on this topic of addressing the imbalance of power, one of the other big ticket items in Labour's manifesto was this idea of creating a single status of worker. So at the moment we operate in a sort of three-part framework where you have genuinely self-employed people, and then you have this umbrella of workers and employees. Deciding whether an individual is a worker or an employee is a legal test, and it's quite a complicated one. There's an awful lot of case law about it, which is something that the Labour government themselves have nodded to in the manifesto, and it needs to be simplified. This is a benefit for everyone to simplify this process because it is confusing for the individuals and also for the employers. There's such a fine line between what steps from a worker to employment status. And we have some employers who are abusing that line to keep people in worker status, to stop them getting the rights that they would otherwise be entitled to with an employee status. And for everyone's sake, clarity is a good thing. There are obviously concerns about simplifying this process. So Labour's proposal is to make this a two-part framework where you have self-employed people and workers. So anyone who is under a contract of employment, or for example, an agency worker, temporary worker, would be in this bracket of worker. They would be entitled to all of the same rights, so all of the employment rights that employed people currently have would be for everyone who falls onto the bracket of worker. Obviously, this does reduce some flexibility for people, and it will increase costs for employers, and I think those are the main concerns that people have about this change. One thing I think it's important to note is that we've heard very recently from the government that this isn't going to be included in the Employment Rights Bill that's in this first 100 days. This is something they're still consulting on. So what this looks like and when it comes in is certainly something for later in this government's year, potentially into next year. Another area that they're talking about making changes are in the areas of redundancy rights and TUPE. The proposal to strengthen redundancy rights is to ensure that redundancy consultation, so we're talking about collective consultation here, is determined by the number of people impacted across the whole business rather than in one workplace. At the moment, we have a concept of business units, where one unit, so for example, in a distribution company, that would be for a warehouse, one warehouse. If employees are made redundant there, that counts towards one count for collective consultation. If employees are then made redundant in a separate warehouse, it's possible that will be considered separately and wouldn't count towards this requirement for collective consultation. The proposed change is that this will no longer be the case, and it will be counted across the entire business. So for companies that have lots of different work sites, this is something to consider. For example, retail, if you're closing one shop and then you close another shop within that 90-day period, those will probably be counted together, and you'd have to activate collective consultation. The proposed changes in relating to TUPE, we don't have much more information on, except that they're going to strengthen the existing rights for workers. What that means and what that looks like, as I say, we've not had any more detail on. We're not expecting that immediately in this Employment Rights Bill. That's sort of a wait and see thing, I think. There's also been mention of strengthening the protections for whistleblowers and for women who report sexual harassment at work. Again, we haven't got much more information on what these strengthened protections would be. It is worth noting that in the previous government, there was a bill that never got all the way through Parliament, which included introducing criminal offences for those who subject whistleblowers to detriment. So it's possible that they might continue that proposal and implement that as a punishment. Finally, part of the addressing this imbalance of power, as I said, is to recreate this framework where you have genuinely self-employed and you have workers. For the self-employed people, they really want to strengthen the protections there as well. The proposals include the right to a written contract, actions to be able to tackle late payments of invoices, and an extension of health and safety and blacklisting protections for self-employed people.
So just to recap, so for the flexible working, it'll be a day one right. You will still be able to turn them down on the permissible 8 reasons. So there's a lot of media about what flexible working means, but still there is the reasonableness and having a good explanation to refuse it. Maternity discrimination, it's unlawful to dismiss a woman 6 months after a return. This is already, I think, in effect. So it's just a bit of tweaking of the language. A review of the carers leave so that it may be considered paid. They say they're going to be mindful of small employers. I think the bigger issue for any organisation is the leave, labelling it correctly and seeing the total amount of leave on the individual, whether there needs to be a permanent contract change or whether any impact on the business by accommodating this level of leave. This idea of having bereavement leave for all workers, more clarification on bereavement leave for workers, the definition of what constitutes family is being changing. Some of you have had bereavement leave for cats, and I make no comments, but clarity is needed on what is the expectation of employees when they go through that difficult process. Whether we're also they're going to introducing this right to switch off, which is a model which is already in place in Ireland or Belgium. I personally will find that quite difficult because if I'm going to do an email, I have to learn how to pause it until working hours. That said, many people that send emails don't expect a response. So I think it's all about context and the pressurised workplace and whether it's a pattern of behaviour. Again, there's going to be this overdue, I think, real analysis of technology and surveillance in the workplace, and that's by working with the trade unions, the employees and experts to really understand what technology organisations are using, what is the impact of those, any algorithms behind them on decision making, rights of privacy, but also how will that impact jobs in the short term and long term, and how are you going to take employees on this skills journey, because the jobs that we have now will not exist in 5 years' time, let alone in 10 years' time, and the fact that there is such a lot of change fatigue with employees, and how are we going to take us all on that journey of working a bit differently in the future for the jobs that are valued.
Another area that Labour have made some big proposals in is in relation to fair pay. So one of their key manifesto pledges was to introduce a genuine living wage. At the moment, of course, we operate under the national minimum wage, which is separated into brackets depending on your age. Labour's proposal is to make this minimum wage a living wage. There's a lot of charities out there that do work on what a living wage actually looks like, how it's different in different areas. And obviously Labour's proposal is to have a consistent living wage across the country, no matter where you live, no matter what your age is. Part of their proposals there are to remove the age bands entirely. It's worth noting that under the current minimum wage bands, if you're between 18 and 20, you're paid £3, just about £3 less per hour than if you're 21 or above. So I think this flattening of these requirements for pay is a good thing, and certainly in that bracket between 18 and 20, there's a real sort of deficit that they have in terms of pay compared to as soon as you hit 21. For a lot of employers are already paying a living wage rather than sticking to this minimum wage. So in actual terms of real effect, it will be for the employer to consider how much they're paying and whether they're hitting this living wage. We haven't got any insight yet as to when this is going to come in, but obviously they do make changes to the national minimum wage every April. So it is possible that we'll be looking at this coming in April 2025, but as of yet we don't have any announcements about that. Along with making this real living wage, there are proposals to amend the Low Pay Commission's remit and to create a single enforcement body which can give penalties for non-compliance for the living wage. In addition to introducing this living wage, this is a multi-pronged approach to create fair pay. As we discussed earlier, they're also intending to amend sick pay, statutory sick pay that is. Part of these amendments are to remove the lower earnings limit entirely, so you don't have to hit a threshold before you're able to receive statutory sick pay, and also to remove the waiting period. Currently, employees have to have been sick for 3 days continuously. That requirement will go and they will be entitled to statutory sick pay from day one. There's also proposals to amend tip rights for hospitality workers so that they receive these tips in full. The plans that Labour have set out in their manifestos are not dissimilar to the Allocation of Tips Act, which comes into force coincidentally on the 1st of October. So if you are in that industry, make sure that you're aware of what this act is and how it's going to impact the dissemination of tips among your workers. There are also proposals to ban unpaid internships. Not a lot of detail about that at the moment, but obviously anyone who's operating unpaid internships should be aware of this moving forward.
So what is significant in the Labour's plan to make work play is the strengthening of bargaining rights and removing a restriction of trade union activity. So there will no doubt be a shift of power, so there will be more union rights. And I think organisations will need to get into the mindset now what that looks like. And unions will have to also perhaps change the way matters have been discussed previously. There is far too much rhetoric you're seeing in disputes, and the best outcomes is when both organisations work together, because ultimately, even if there is ultimately most employers have some global footprint, and it's about keeping good jobs in the UK. And there is a concern that if the balance is not done, not working for the common good, that will cause great difficulties. So what have we seen in terms of actual change? We've seen repealing the minimum services level strike act. Well, that was a no issue. No employer had ever used it. This was for limited sectors such as transport and health, where there had to be a minimum service level of delivery. So it came and go without any kind of implementation, really. So it's a real non-issue. What the plans include are, for the care sector, sectorial collective agreements. And this is when the sector, with the unions, with the employers, agree the terms that is offered to every single employee in that sector. So there's no argument about one employer offering better terms. They can offer better terms than that, but it's raising the benchmark. And that is quite a good sector to go for, because it's one of the sectors that has real low pay, not security, and it's a crucial sector that we need. So one way that these could work is to really raise the bar quite quickly in certain sectors. But the idea will be that once that's agreed in one sector, it will be in place for other sectors. So it's the beginning of sectorial pay agreements, which happen in Europe, which happened in the UK until about the 70s. Then there's going to be this simplification of the union recognition process. So at the moment, you have to determine what is the correct bargaining unit. That could be a department, that could be an organisation, that could be workers within that organisation, a group of workers. But now you'll be looking more widely at what is the bargaining unit. And the unions will be looking at your organisation saying, well, what bargaining unit do we want to represent workers in? At the moment, in order to get statutory recognition, you can always voluntarily agree. What you say is that I've got 10% of my union members in that bargaining unit. You then have to show that the majority in their workplace want the union to be recognised. 50% doesn't seem a lot to me. It's only 50% of the workforce that is there, and it's one of the union challenges to justify to their members why they should represent them. So they have some challenges there, but it is concerning about what those thresholds would be, and I think that's what detail and the ability to look at those details and in certain sectors. So one of the industries like the gig economy, it's very hard to get that thresholds because they're very hard to contact and wire agency workers and things like that. So I can see that in certain circumstances, they're not really changing the 50%. It's a different way of getting there. I can understand that. Electronic balloting, this is such an archaic piece of legislation where if you're doing balloting, it's an actual postal ballot. The reality is that for employers, if you're balloting, say for industrial action, it does buy you more time for planning, so that your contingency planning will need to be updated and taken into account. What we will also see is right for access in workplaces for unions. I don't think many will have an issue, but this is essentially they will be able to put their stalls out and talk to your employees, and that is, I don't think there's going to be any issue with that. That's relatively easy because it allows workers to see what's on offer, and this idea that actually there needs to be a bit more co-determining on essential issues. What you'll also see is at the moment, if you're having a statutory recognition agreement, there are limited things that the union and the employer talk about: pay, hours, holidays, and those will definitely broaden, so there'll be more things. So if you're struggling with those three and there's a shift of power, how is that going to be negotiated to the better good of all? And I do think there's got to be less rhetoric in both how organisations and individuals and unions talk to each other. Lots of employees have very good industrial relations, but there's shifting sands, and we will see the consequence of that. So it's a really complicated and difficult area which really needs very good consultation. So no one is cutting their nose to spite their face. So we wait for that, but we think, although the unions will not be happy because we do not know what we're promised to them, that this should take some time. But you are on a journey now of more disclosure of information, collectively consulting, say redundancies, having your reps in place, and that kind of interaction.
So another area again of Labour's proposals is this concept of equality at work. Obviously, we've touched on some of the proposals that bring in towards sort of family-friendly rights to increase this equality. Fair pay obviously touches on this equality at work as well. But in addition to that, there's some very specific amendments that they're proposing to do with pay gap reporting and equal pay. So obviously equal pay is quite a topical issue at the moment, and Monica will touch on a little bit about the next case that's just concluded. But Labour's proposals for equal pay are that outsourcing cannot be used to avoid paying equal pay. They very specifically want to get that into legislation. They want to introduce a regulatory enforcement unit to enforce equal pay. And they want to ensure that single source comparators are permitted. This is already permitted, so we're not entirely sure what legislation they're going to bring in to ensure this. But certainly in the wake of the next decision, as I said, Monica's going to touch on that, there will be some legislation we expect on the area of equal pay. They're also planning to introduce new requirements for pay gap reporting. So for large companies, this is going to be action plans to close the gender pay gap. We're not entirely clear yet what's going to have to be in those action plans or how they're going to be enforced. But for those who are already reporting on the gender pay gap, they should be looking at steps that they could include in an action plan. A lot of employers already do this anyway when they're doing their gender pay gap reporting. There's not a great deal of point in reporting on it if you're not making any plans to fix issues where you see them. In addition to that, the government are planning to introduce an obligation to report on ethnicity and disability pay gaps. This will be made mandatory for employers with more than 250 staff. A lot of employers already report on this when they do their gender pay gap reporting, but for those who don't, this is something that they're going to have to start looking into. A final area that Labour have focused on for equality at work is the idea of supporting those going through menopause in the workplace. They're proposing to introduce this obligation for action plans as very similar to that for the pay gap for more than 250 staff. Employers will have to set out how they plan to support employees through the menopause. And as we said, it will be very similar to those for the gender pay gap. It is worth noting that in February this year, the EHCR produced some guidance about menopause in the workplace. In this, they set out that menopause could be considered a disability under the Equality Act, and exactly how that might be the case. Obviously, this is on a case-by-case basis. It won't be the same for everyone, but employers should have this in mind when they're considering how they best support their employees going through menopause. And it may be worth considering whether any amendments to policies are needed in light of this.
So talking about some enforcement changes, there's to be a single enforcement body. This is not new. It was proposed before, because what you find is where there is real abuse, there's not joined up thinking or enforcement. So if you have somebody who's not being paid a national minimum wage, you're more likely to find abusive relationships. And it's ironic that at the moment, if you get an audit, you get named and shamed like 4 years after the incident. So having a single enforcement body to enforce inspections of workplace for illegal working, for example, which goes hand in hand with underpayment, that is what the single enforcement body is. And it's been an idea that's been around for some time. Employment tribunals, there is the digitalisation of the employment tribunals, which Lucy and I are going through. Everybody, whatever the deadline is, we're now hitting at least 2 days before, because I'm just a bit anxious about the digitalisation of it, but it is working well. We've done CDP hearings, so that's nothing particularly extraordinary. Strengthening enforcement through the tribunals, I don't know what that would actually mean. I don't know the stats of when people lose cases and then they don't pay up on those cases, but it's a small fraction. I think, again, it's very important that it is sorted out. There will be, by this increase of legislation, there will be more tribunal claims. And that is a cost, and that needs to be factored in with prevention measures. And then you'll have to move your electronic redlining in your diary of 3 months plus 1 month ACAS conciliation to 6 months plus 1 month. So that extension of bringing claims will happen. I would already say now that the ability to hold on to evidence and witnesses is really important. So you should be considering, when you're in a dispute, of capturing that sooner. The tribunal system is still very overworked, and we have long hearing dates. There will be the ability via ACAS to bring collective agreements, which is a new concept and quite a helpful one in that obviously ACAS has specialisms in mediation and dealing with those kind of issues. There will be modernisation of health and safety guidance to take into account the new ways of work which haven't quite kept up. And there's the idea of strengthening legal duty to stop sexual harassment before it starts, which is a interesting concept because part of this is maybe societal change that needs to happen, which doesn't necessarily always fall when they come to you as employees. That's a bit late sometimes. So it's this idea of, really making sure the standards are clear and obvious about what it means to be an employee within your organisation. Just wanted to quickly talk about some cases. Lucy thought these cases were interesting. She chose them. So, and she's not wrong, but just to give you a flavour that whilst the law has been changing slowly, case law has been actually quite phenomenal in the changes that it has brought into the UK framework. So we've had the next case come out, which was a equal pay claim where the retail staff in the shops were compared to the warehouse staff. It's actually a very long judgment. It dealt with lots of elements of pay, basic pay, allowances, bonuses. There were about 7 different pay components. Each one of those were determined, what the pay differential was. The 2 takeaways is that when you do a equal value claim, even though the jobs look very different, when you do that assessment of skills, experience, requirements for the job, the retail workers came out slightly higher than the warehouse. And this is partly historic thinking, old-fashioned thinking of jobs and putting people in those jobs. But on the actual pay, Tesco ran 6 material factor defences. Some were successful, some weren't. But more interestingly in this case is that when they were describing the pay difference, so Lucy and I get paid a different rate than a male comparator, it's quite hard to get it. It's because we're women. That's a high hurdle to pass. This case established that the mere fact statistically Lucy and I get paid less, but most women would get paid less, means that the indirect provision has already been met. So it's almost like that's a very easy checklist to do when you're doing those kind of cases. This is how old the backlog is that we're getting COVID cases still being determined. This is just an interesting case in that you can see that they were a healthcare company. They had a requirement for mandatory COVID vaccines. Of course, it's your individual right whether you have vaccines or not. But what this case was establishing is a well-established principle that an employer is entitled to have firm rules. And as long as they can justify it, and as long as it's not tainted by any kind of discrimination, and you can objectively justify some forms of discrimination, that a termination would be fair for that kind of process. The other case is, again, I don't think new law at all, but it's a good reminder. When you have got to the end of a very long and difficult ill health dismissal process, where you've had lots of absence, lots of meetings, lots of phrased returns back to work, and you're all at the end of your tether, what the courts say is that at that point of dismissal, it is on the employer to consider redeployment, and that must still happen. So, and it may not be redeployment in the same or same level job, it could be a lesser job at a lesser pay rate. This idea that as we go through our working lives, we'll go up and down the scales to accommodate our circumstances, and that was the failing that didn't happen. You don't have to create a new job, but this idea, is there a deployment opportunity at a different level? The British Airways case, that's an interesting case in that there was a scheduling amendment, and that scheduling amendment impacted people from overseas who would commute into work from overseas, so that was an indirect race discrimination case, and it impacted women because women still have the childcare burden. The Supreme Court held you don't even need to prove that, that's a given, that we're still looking after the children. And what happened is that there was a male who had caring duties, so he didn't technically fill into the test of indirect discrimination, and he was held to have the characteristic in the pot. And same for a UK citizen that lived abroad, so it wasn't connected to race, but was impacted by the scheduling. So that just shows that you do not have to have that protected characteristics to benefit from the group disadvantage of a practice, criteria or provision. So I think now we have time for questions. I just need to give Lucy a little bit of time to see if there are any questions. I know one of the questions that always comes up is, will you be getting a copy of these slides? And yes, you will be getting a copy of these slides.
That was indeed question number one.
Oh, okay, it's all good.
So, question number 2 is, can I just double check that third parties are covered by the workers' protections legislation that comes into effect next month? I thought the legislation fell short of third parties.
So, yes, so we're going to play a scenario. I am a very rude customer to Lucy, and I'm being very rude to her. So Lucy is protected, and her employer, she has a claim against her employer for my actions. If Lucy is rude to me, because I'm such a nice retail shopper, and she's rude to me on the grounds of whatever, she says a derogatory comment about my age, my menopausal symptoms, and I shouldn't be wearing something, I don't have a standalone claim, if that's what the question is saying. So that's right, it did fall short on those kind of, the third party in itself is not protected. A third party can do a lot of damage, so it's all about, it's not just the tribunal claims or the discrimination claims, it's about managing your reputational risk. So both Lucy and I will be in trouble in both scenarios.
So we've got a couple of questions about this day one right for unfair dismissal. Obviously it's a contentious one. So firstly, just more of a comment that this will impact the already significant backlog on employment tribunals, which will certainly be the case, I think. Especially with the extension from 3 months to 6 months, if those two go hand in hand.
I don't disagree with you. There was a time, when you're getting to an age where you can't remember, which is just disastrous. There was a time when the cap was reduced, the qualifying length of service. I think it's like 2 decades. I can remember which office I was in when it happened, and I remember just sitting there. The claims were incoming, but at that time the tribunals were dealing with them in 6 weeks, so we don't have that correspondence. I do think that if you have these claims coming in and an employer has this really tight process on recruitment where it's saying, this is the job, this is what I explained what the job was, this was the onboarding, these were the policies I made you read, because they only read the policies at the beginning, all your handbooks are however many pages are. If you have that and then you have this really tight onboarding, so you're showing that actually this employee never was going to make the standards, not that there's a little gap there, you're having your reviews at 1 week, 2 weeks, 3 weeks, whatever it is, tracking that. There must be a mechanism in the tribunal system that I'm hoping that these are very simple one-day tribunal listing, get in front of a judge, go, go, go. I think there must be this simplification of it. I think there does need to be a better sifting out of, well, not only was I rubbish at my job, but you're picking on me because I have got protected characteristics, and there's the ones that you are seeing that normally you do get rid of quite quickly if they are as shallow as that. But then you have other cases, and I think you're talking about the whistleblowing cases where you've seen real detriments to people that have blown the whistle, like the duty in the case I'm particularly thinking about, that on the face of it, it looks like there's nothing to it, but when you drill down, actually there was significant miscarriage of justice. Post office inquiry, for example, if you don't do a thorough review of the evidence for dismissal, but I think there should be some kind of streamlining of those kind of cases. Again, I have seen nothing which says there'll be more funding for the tribunal system. Interestingly, there was a case that I was reading this morning of a psychologist in the NHS. So we have this big pay award today, and that will have ramifications across the organisation, the NHS. But it was a psychologist in the NHS who resigned, claimed constructive unfair dismissal because they said, you just didn't give me the support and team that I needed, and she won a constructive unfair dismissal case. So it's the bargain both ways of what you're promising the employee in that recruitment stage.
So the other question we've got on unfair dismissal is, will the changes to unfair dismissal impact employers' right to extend a probation period if we have any cause for concern?
I think it will. Lucy, you agree with that, don't you?
Yeah, absolutely.
I think you're going to have a hard cut-off period. So what we don't know is whether that's 3 or 6 months. And it really does depend on the industry. There are some organisations that are so unique to themselves and complex that it takes you 3 months just to get your bearings around that kind of thing. I do think there'll be more proactive management you can get to that. So if the law is saying you have your unfair dismissal rights, by 6 months, extending your probationary by another 3 months will not get you protection. You may be able to do it from 3 to 6 months, so you might want to have that assessment before that hard cut off. And that's not a bad idea because, Lucy and I aren't sceptical, but, people might tend to have some absence when they're nearing their failure of their probationary period, and those kind of things. It's the dance of the employment relationship.
It certainly seems that you want to be checking in more often than not during the probation period and making sure that their performance is being reviewed. Make use of that probation period properly. So I feel like a lot of employers potentially just sort of let them slide through the first.
Yeah, and then panic and then put it in the diary, and then it's very easy to get out. So you just need to be a bit tighter and on the evidence as well that you have got the poor performance or attitude.
So we've got a couple more questions still. So we've got a question about the whistleblowing and increased protection for women reporting sexual harassment. So they're asking if there will be any amendments required to company policies, or is this just going to be a strengthening of legal protections?
I think it'd be a strengthening of legal protections. I think there does need to be some amendment to policies. I am concerned that you're really good at doing policies, but they don't hit the audience because it's just another policy. And we're as a law firm, we're equally, we've got loads of policies, but how you implement those. The issue that I struggle with as a practitioner, and with this, we have core sense of real justice, is that I think it's really important that you have an environment where there is a duty to report wrongdoing. And at the time it happens, because then you can capture evidence, you can deal with it. There is issues when that's done anonymously. So having protection for somebody that says something is not, it also means that issues don't escalate, because lots of things can be, stupid phrase, nipped in the bud, or you see a pattern developing depending on seniority and things like that, the same complaint is coming in. And I have seen both, we've seen both sides of it, as you will have done, but there are sometimes malicious complaints or just misguided complaints. And you have people making statements that cannot be proved or disproved because of the passage of time. So I think that I would be saying to people, speak up and be confident that this is an organisation that will not take any penalties unless you're knowingly lying. And there are very small people, there's lots of misunderstanding, and the cases that we see, they are always, I'm afraid to say, nuanced. There's no real villain sometimes, or no real victim, and it's this idea of having those difficult conversations about social dealings and things like that, and it runs across cultures, and it runs across groups. Sometimes I can't understand what my child says to me because of the language that they use. So it's that kind of phraseology about misunderstanding. So that's what I think I would be saying to employers, really, to have your speak up and an obligation to say, you've got to say it now, even if it's a small matter, say it now. And getting over the hurdle, that is quite difficult for somebody to do that. It's, they feel that they are going to lose their jobs, or should they shut up and put up with it? So those are the real complicated, difficult challenges, I feel.
So we've just got time for a couple more questions. Firstly, quite a technical one, but is for gender pay gap reporting, are the obligations for companies with more than 250 employees in the UK only, or is it 250 employees worldwide?
I think it's in the UK only, but I'd have to look that up. That is a horrible technical question, isn't it? You normally get those. You're normally good on those questions in April, aren't you? Because that's when everybody's putting there and you're checking and you're just saying, oh yeah, that's fine. Yeah, okay.
Okay, so yeah,
we think that's the answer.
We think that. So we've got a question about parental leave. If this is a right from day one, won't this create issues for employers where staff could join the company when they know they already need to take leave and not advise the employer?
Yeah, so I think this is the reframing of the employment relationship. I'm going to be a bit controversial, but I think there's an over sense of entitlement by everyone, about individuals, by organisations. Everyone is quite individualistically thinking, and therefore having this collective, either via unions or via forums, or there is not a bad idea. So if you're putting out an advert, I think it's important to say, this is the job. If you've got any requirements, be honest with us, tell us, because most people, most organisations accommodate leave all of the time. You do it all of the time. Every organisation that we work with can give thousands of examples of the give and take that makes the relationship work. What you get angry with is that you think you're recruiting for a job, you think it's a 5-day job, people come up and then there's a whole list of things, and it could be health issues, it could be working arrangements, and the idea is you say to them, you need to tell me now, otherwise, controversial, I would say, it's a breach of the trust and confidence, and that's a phrase that's used in employment all the time, but essentially you're saying is that you've got to be honest with me, and if you're not honest with me, it's the lie. But you have to have that framework where employers will sort of say, yes, I can sort of discuss that, because if you have somebody that needs to take time off, you may be able to do some cover arrangement, say notice pay, but it is very problematic and it does start the relationship off. Now, just because it's a day one right although I've said my bit about entitlement, I think most employees will think, oh, that doesn't look good, you know, excuse me, do you think I could have my induction? Can I give you 6 months notice of my leave, please? No, that's what it is. But then, you know, sometimes you can't coordinate life and you find everything going wrong at all of the right time. And there is some provision really about ensuring, employees, when you're talking to them about returning back to work or when they're having leave, about things like care provision and cover. I've been a bit shocked this month that some people have said to their employees, no, we're working at home because we can't afford the nursery, but we can do both jobs. And I'm thinking, oh no, it is still a contractual relationship. Your duties to faithfully in your working hours to do the job and not look after others.
So one last question. Any signs of employment tribunal fees being reintroduced?
Oh no, we haven't heard. No, that's not going to happen. I've not heard of any of that in the late. That was a Conservative Party thing. I've not seen of that. I don't. Yeah, and the fee before was quite a low fee. It was a couple of hundred, if I remember correctly. And I don't know whether a smaller fee might have the impact. But the problem with a fee is that the people that need the tribunal system the most won't be able to pay that. But if they're in a union, they probably would be able to get that cover. So I think the question is more about the cost of what this is going to cost employers, especially if there's more tribunal claims and the witnesses, they're just no longer with you because an employee with 5-year tenure is sometimes a rarity in the organisation.
I think that's it. That's all of our questions.
Thank you very much for joining us. We hope you found this useful. Please fill in the surveys at the end, and of course you can email either Lucy or I if there's any follow-up questions you want to ask. But thank you very much for joining us.
Thank you.